Good. Okay, all right, that's done. Are you ready to begin?
Yes, I'm ready.
Good. In which case, I'll give you a countdown from 3 and then we can kick off. So, 3, 2, 1. Yes, please.
May it please the court. I am appearing on behalf of the applicant Onyx Limited, who is defendant in this case, and my learned friend Miss Briggs is appearing on behalf of the respondent Ruby Limited, who is claimant in this case. Judge, this is an application to set aside a default judgment under Civil Procedure Rules 13.3 entered on 19th April 2023 against the defendant. In paragraph 2 of my skeleton argument, I have listed the documents that I will be relying upon for today's submission. May I confirm that you have had the opportunity to go through them?
I have, but none of them were emboldened despite what you've said in paragraph 2, so I just read them all.
I'm grateful. Just before I proceed with this my submission, would you like to be acquainted with the facts of the case?
I'm already acquainted with them, thank you.
Much obliged. Judge, I'll now proceed with the test of setting aside the default judgment. I have set out the applicable laws
You set out paragraph 7 and
in paragraph 7 to 9 of my skeleton argument.
Look, I'm happy I understand the test based on what you've said, so I don't need any further help, thank you.
Much obliged. Judge, in paragraph 10 of my skeleton argument, I have laid down the issues that I will cover in my submission. First, I will deal whether the defendant's contract is valid. The second one, whether the defendant breached the contract or not. And the third one, whether the defendant intentionally failed to respond to the claim of the claimant. And the final one, whether defendant was prompt in making the application to set aside the default judgment. Judge, I will provide my submission into 3 parts. In the first part, I'll prove that the defendant has real prospects of successfully defending the claim and there is a good reason why the judgment should be set aside. In second part, I'll deal with the promptness and finally, by applying the Danton principle, I'll demonstrate that it will be just for the court to set aside the default judgment. Judge, I will be dealing with the real prospect of successfully defending the claim. It is submitted that the defendant has the real prospect of successfully defending the claim and defendant did not breach any terms of the contract. Judge, if you may look at paragraph 12 of my skeleton argument, the defendant state that on 9 March, the claimant sent an offer to the defendant and after 7 days of receiving the initial offer, on 16 March 2022, defendant sent a counter offer by revising the terms of the contract. As per the case Hyde versus Range, a counter offer has the effect of destroying the original offer. Therefore, the original offer is no longer open for the offeree to accept. Judge,
can I just ask you a question about the way that you formulate this in your skeleton argument? So at paragraph 10a of your skeleton, the issue which I think you're currently addressing in your own words is whether the defendant's contract is valid.
Yes.
First of all, I don't understand how there can just be a defendant's contract. Surely it's the contract which exists between the parties. But more than that, we're not really talking about validity, are we? Neither party disputes the fact that there's a contract between them, do they? Is it right that we're talking about validity?
Yes, whether, yes, I understand whether the counter, I wanted to submit that whether the contracts made by them is valid or not.
Again, neither party disputes that there is a valid contract between them, do they? The dispute is over the terms of the contract, isn't it?
Yes, different terms of the contract. Yes, my judge. Yes.
I see. Okay, thank you.
Judge, we were at paragraph 12 of my skeleton argument. Judge, if you please look at the case bundle, the highlighted portion, second page, if you could read that to yourself.
Yes.
It is submitted here the defendant's counter offer destroyed the initial offer made by the claimant. It is also mentionable that the defendant commenced work only after revising their terms and upon giving the counter offer to the claimant. If I may take you to the exhibit ER2, ER2, the last paragraph, Ruby's payment of £40,000 to Onyx on 10 June 2022, which payment will be made after Dodo has been made available for download, amounts to the acceptance of the terms set out in this document, such that a contract between us takes effect on the date on the terms stated above. So the contract between the claimant and the defendant will be governed by the terms provided by the defendant rather than the claimant, and this answers the first issue of the case. Moving into the second issue, Judge, if you kindly look at the third clause of Exhibit ER2, if you could please read that to yourself.
Yep.
Please note that the claimant did not carry out the certification process by first registering with the relevant insurance provider. Rather, they carry out the certificate process without first registering with the relevant insurance provider, which for which reason Dodo did not work. Therefore, the defendant did not breach the contract, and this answered the second issue. Additionally, the claimant alleged that SMS were not sent to the patients in a timely fashion. However, they failed to provide any evidence to support this assertion. In order to find out the exact reason for this problem, relevant testing is required to be carried out. Moreover, claimant never reached out the defendant for solution to this issue. Nonetheless, this does not include that the defendant was in breach of contract. Judge, if I may...
It's not true to say, is it, that the claimant has provided no evidence to substantiate what they say? That's just not true, is it? Because if you look at the witness statement of the claimant's director, it says in terms that the SMS aspect of the software did not work as it ought to have done. What more evidence do you want than that?
There are substantial... I was asking for substantial evidence was not provided by the claimant for the assertion or the claimant made that SMS were not sent to the patients in a timely fashion. That I wanted to submit before the judge.
Okay, and I will say to you again that there is evidence, isn't there, because of what is said at paragraph 6. I mean, she says that the SMSs didn't go out, and then she says we had to pay £35,000 to auditors. It's fairly unlikely that they're going to have to pay £35,000 to auditors if everything worked as it should have done, isn't it?
Yes, there is a witness statement given by the claimant. But my submission here is that if, Judge, if I may take you to the second last paragraph of Exhibit ER2, if you could read to yourself.
Yes.
Therefore, even if the defendant is liable, its liability is kept at £40,000 only and not more than that.
That I understand. That seems to me to be a different point to the one that you were just making. I can understand if you're saying even if there was a breach of contract, liability is capped at £40,000. I understand that entirely. It just seemed to me that you were questioning the evidence which had been provided to substantiate that particular loss. That was my point.
Yes.
So if your point is irrespective, limited liability to £40,000, I understand that.
Yes.
That's fine. Thank you.
May I proceed?
Please, by all means.
Therefore, defendant claim is realistic one that carries conviction. Hence, it is submitted the defendant has a real prospect of successfully defending the claim. Judge, I'll now move on my next submission. Is there some other good reason why the defendant, why the judgment should be set aside or varied? Judge, if you please look at paragraph 14 of my skeleton argument, The defendant Elizabeth Raab is the managing director of Onyx Limited. She filed the acknowledgement of service but failed to file any defense due to the misreading of the rules. Moreover, Ms. Raab is not a lawyer and lacks the benefits of a designated legal department or staff to assist her. Hence, defendant failure to file the defense was not intention at all. Rather, it was done to save cost, as Onyx Limited was not in the best financial situation. This addresses the third issue. Therefore, it is submitted that the default judgment should be set aside and the defendant should be allowed to defend the claim. Judge, if I take you to the paragraph number 15 to 17, which deals whether the defendant made this application promptly or not, it is submitted the defendant has acted promptly in making this application. There are a total of just 13 days between the judgment in default being entered and the application is application to set aside being made. The default judgment was entered on 19 April and the defendant received on 20 April. Immediately after receiving the judgment, defendant made a contract with his solicitor on 25th April, and immediately she made this application to set aside the default judgment on 3rd May 2023. Therefore, it is hereby submitted before the court that the defendant was prompt in making this application. Judge, I would also like to bring attention that Ms. Raab, as the managing director, as I have said earlier, and she lacks legal expertise. She filed the acknowledgements of service on her own in an attempt to save costs. She misread the rules and failed to file the defense. But after getting the default judgment, immediately she made appointment with the solicitor and made this application without any delay. So I can submit that Onyx has acted promptly and without delay. As such, the fourth issue is dealt with. As this is an application for relief from sanction, Judge, I am at paragraph number 18 of my skeleton argument. As this is an application for relief from a sanction, Denton must be considered. Denton provides a 3-stage test to be considered by the court when exercising its discretion, namely, whether the breach has been serious or significant, why the default occurred, and all the circumstances of this case. As discussed earlier, Denton test comprises of three parts. I will first deal with the serious and significant breach. It is submitted that the breach was not serious or significant, as a little time has elapsed since the original date of the defense. Moreover, it did not imperil future hearing dates, and it has not disrupted the future conduct of the litigation and has not caused a delay that will impact the claimant's ability to present her case. Judge, if I may bring your kind attention to paragraph 20 of my skeleton argument, the court does not need to progress to consider limbs 2 or 3 if it is satisfied that the breach was neither serious nor significant. It is respectfully submitted the court should be satisfied. But for completeness, the remaining limbs will be discussed now. Coming to the second limb, why the default occurred. Judge, the default occurred as the defendant was trying to sort out the matter on her own since the company is going through financial difficulties. Her intention was to save costs, and Ms. Raab lacks the legal expertise. She files a acknowledgement of service, but she has failed to file the defense, and she thought that she had to file the acknowledgement of service only, which she did. Therefore, it is submitted. There is a good reason as to why the default had occurred. Judge, I am at paragraph number 22 of my skeleton argument. I am coming to the final limb, all the circumstances of the case. It is submitted that the dealing with the matter justly favors the granting of the application. Thus, despite demonstrating real prospect, good reason, and promptness, if the court does not grant the default judgment to be...
That's time. Thank you very much indeed. That brings us to the end of the assessment. There's nothing else I require from you. You're now free to go. Enjoy the rest of your day, and best of luck with any other assessments that you have to set. Thank you very much indeed.
Thank you.